there's a form for you to fill out in our closing package that instructs us to either wire the funds to your account, or we can mail a check to you or overnight a check to you. We try really hard to make sure that everyone gets their money on the same day of closing. However, there are times when the funds do not get posted to our account before our 4 o'clock cutoff time. So it might be the next business day before you get your money. In most circumstances, you should receive your funds either the same day of closing or the next business day. We can assist with the closing on a pre-foreclosure transaction, provided the mortgage company will give us a payoff and delay the foreclosure date if needed. All liens, including child supports, will be collected for and paid at closing. The amount of funds to be dispersed at closing will be the sales price minus the prorated taxes. The seller will either pay the taxes for the full year and then receive credit back from the buyer for the number of days the buyer will own it, or the taxes will be prorated based on your closing date for you to give the buyer credit to pay the full year when taxes become due. Just for instance, if the taxes are $2,000 a year divided by 365 days, that would equal $5.47 a day. And if your closing was on March the 30th, $5.47 times 89 days would be $486.67. Therefore, the sales price of $100,000 minus the tax proration of $486.87 would result in your proceeds of $99,513.33. However, if you have any mortgages that are due or any other liens, those would be deducted as well. Taxes are prorated at closing described above. However, if the actual bill in October of the closing year is more or less than the amount used for prorations at closing, the buyer and seller would be responsible for the amounts due to the affected party. Capital gain questions should always be directed to a CPA or tax specialist. Typically, a sales price under $250,000 for a single person and $500,000 for a married person for a homestead property are not taxable, but does not mean they are never taxable. Inherited houses from deceased owners would require either a probated will or an affidavit of heirship. A probated will would require the courts to appoint a specific person to be the executor of the estate to sign all closing documents. You will be required to have a bank account in the name of the estate. Okay, all proceeds will be paid to the estate only. If the deceased did not have a will or the beneficiaries under the will chose not to give the will legal effect, then the title company prepares an affidavit of heirship. However, in order to give legal effect to the will, it generally must be probated within 4 years of the deceased date of death. If the deceased passed away in 2010 with a will, but it was not probated, then the will is no longer effective and the title company would require an affidavit of heirship. If we will be preparing an heirship affidavit, a family member will be required to complete a questionnaire concerning the deceased's marital history and children. The questionnaire will also require 2 disinterested witnesses which knew the deceased for at least 10 years, sign the affidavit along with the family member. If the person passed away less than 1 year ago, there would be additional requirements. We would need a letter from the hospital showing a 0 balance for medical bills owed, and also the same from the funeral home. Yes, both parties will be required to sign when you are in the process of a divorce. Often a divorce decree will award one spouse the home with the requirement that the other spouse provide a deed after the divorce, conveying all their interest to the spouse awarded the property. which is sometimes not done. In this case, depending on the wording of the decree, we may require additional documentation in order to comply with the divorce. We will order a copy of the final divorce decree. The examiner will review and update our commitment to show just you in title. You would then be the only one required to sign the closing documents. Yes, provided the sales price is more than the payoff. We will need the original power of attorney to record in the county of the property, and the person you gave authority to will sign all closing documents on your behalf. We can close the sale of the property once the probate is finalized. After closing, the mortgage company will receive the payoff funds from us, and they will reimburse you for your taxes and insurance in your escrow.